Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. Now, you have been asked to come to court this morning for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. We only have a criminal case. We have some civil case, but the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your most serious type of offenses, whereas your misdemeanor offenses are referred to as your petty offenses. It doesn't mean that they're not serious. It just means that they're not as serious as a felony case. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment, minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine up to $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Okay? Now, as I mentioned to you earlier, you have a misdemeanor case, so you don't have to worry about those punishments. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanors are cases that start in the city court, or that's the municipal court, or the JP court, which is the justice court. For example, speeding is a Class C. Not having your seatbelt on, Class C. Not having your driver's license, Class C. And so those are Class C misdemeanors. Now, with a Class C misdemeanor, you cannot be given jail time. The range of punishment is by a fine only. So you don't be given a fine from $0 to $500. That's the max. Now, the Class C misdemeanors, as I told you, start in the municipal court or the JP court. They come to this court when a person is found guilty in the JP court or the misdemeanor court, and then they appeal their case. And that's if they want a higher court to review the case, and they get a whole new trial. And it comes here. The range of punishment doesn't change. Okay? It's still the same. Minimum $0 to maximum $500. Now, if a person failed to pay the fine, or if their fine was converted to community service, whether they're working off, and they fail to work off the community service, then the court can issue what is called a capias pro fine. A capias pro fine basically means it's a warrant for the arrest of a person who failed to pay the fine, or failed to perform the community service. And then that person get arrested, they go to jail. Every day that they sit in jail, $100 will be credited toward the payment of their fine and court costs. That's how it works. Okay, now the next highest misdemeanor, I said you had Class A, B, and C. The next highest misdemeanor above the C is the B. Now, with the class B misdemeanor, the range of punishment, if you're convicted, is minimum 0 days to a maximum of 180 days in the county jail. Or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Then you have the highest misdemeanor, which is a class A misdemeanor. A person is convicted of a class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, let me do this here since I'm talking about punishment. You also have a right, and you may be eligible for what we call probation. What probation basically means that you won't be going to jail, but if you're sentenced to go to jail, you will not go to jail, you'll be out on probation. Okay. So, for example, there are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And the other type of probation is just called adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure, which means we cannot tell the general public that you are on deferred adjudication for this case. So in essence, your record is sealed to the general public. Notice I use the word general public. And that just simply means that the government can have access to it, but not the general public. Most of the public is the general public, so it's sealed to the general public. Now, the other type of probation is called adjudicated probation. We usually call that regular probation. We call the other probation the unadjudicated probation, deferred. So with the regular probation, it does result in a conviction in record. However, if you successfully complete the probation, the court have the authority and the power to grant you what is called judicial clemency. That is, the court can set aside your conviction, and you won't have a conviction on your record. Now, the way it works, three things have to happen. First, you have to successfully complete probation. That's one thing. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged off of probation by the probation office. Those three things happen. The court has the discretion to set your conviction aside, and you no longer have a conviction. Now, however, if you get a subsequent conviction, you can get another conviction later on for some other case. Then the case that you receive judicial clemency on can be resurrected, brought back up, and used against you. And if you try to get a license with Child Protective Services, CPS, they can deny giving you a license, or if you have a license, they can suspend or revoke the license that you have. Now, everyone in here who's here for a case, you should have a clipboard with some paperwork on it. I'm going to go over that paperwork with you. Now, as a defendant in a criminal case, you have a right to have an attorney. That first document on the clipboard should be titled Judge's Explanation of Rights to Defendants Without an Attorney. Okay, now everybody, you will initial and sign that document. Now I'm going to go over this document with you. As a defendant in a criminal case, you have three options. Number one on that document, you may hire an attorney. Number two, if you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. Number three, you may represent yourself. Those are your three options. Now, the first paragraph states that if you want an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means that you'll be given another court date. And that's, will give you time to hire your lawyer. Next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed by the court to represent you. But you must first fill out a financial questionnaire. On that clipboard, there is a document. It's a 3-page document. It's titled Jefferson County Affidavit of Indigence. That's the title. Jefferson County Affidavit of Indigence. So, that's the document that you would have to fill out if you want an attorney to represent you. Now, you will fill out the first page, and on the second page, you will fill out the top of that document that's titled Defender's Oath, just that box. And then you go down here to the bottom of the second box where it says unsworn declaration. You'll fill that out and stop. Okay. And that's all you need to do. If you want an attorney, and then the court will fill out the remainder of that document. Okay, now I'm going back to the judge's explanation. Again, the next sentence says that you may not speak to the attorney or to the prosecutor to my left, to your right. We have 3 prosecutors. They are assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. If you represent yourself, you will have an opportunity to talk to one of them today to see if you can settle your case. A plea bargain. Okay, you have a right to talk to them. Why? Because you're representing yourself. In essence, you're acting as your own lawyer. But you must first fill out a waiver of your right to an attorney. Now, a waiver is another document on that clipboard that is titled, it's a 1-page document, that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. It's a 1-page document. And it looks something like this. This is the document. It's a 1-page document. You have to read and sign that document, and then you'll have an opportunity to talk to one of the prosecutors. Next, the next paragraph says that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including your case, and you may lose significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you decide to represent yourself, the next sentence says you may change your mind at any time. So, for example, let's say you're in the state, have talked, you didn't like the plea bargaining agreement, and now so you can request the court. You can request that the court appoint you an attorney. Okay, so you can change your mind at any time. All right. Now, at the bottom of that first document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now you're going to see 5 lines at the bottom to the left. If your choice is to hire your own attorney, then you will put your initials on the first line to the left. You will sign your signature on the line where it says defendant, and you will date today's date, November 5th of 2024. And if that's the only document you have to sign, if you would like to hire your own attorney. That's it. If you want to request a court-appointed attorney, Or let me go back up. The line 2 says if you've already hired an attorney, then you place your initials on the second line to the left and the name of the attorney on the line to the right. Okay? And then you'll sign the document and date November 5th, 2024. Now, if you want to apply for a court-appointed attorney, you want the court to appoint an attorney to represent you, then you will place your initials on the third line to the left. Okay? And you will sign the bottom of that document where it says defendant, and you will date it today's date, November 5th, 2024. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney to the right. You sign the document and date it. Now, if you want to waive your right to an attorney, that means to give up your right to have an attorney to represent you, and you would like to represent yourself, then you will place your initials on the fifth line to the left. Once you finish placing your initials on the fifth line to the left, then you will sign your name on the line that's titled defendant, and you will date it today's date. And then for those of you who will be representing themselves, you will also have to sign the waiver of counsel. So let me just summarize this. If you want to hire an attorney, you only sign one document, and that's the judge's explanation of rights to defendants without an attorney. That's it. You don't have to do any more. If you want to apply for a court-appointed attorney, you sign the judge's explanation and the affidavit of indigence, and that's it. If you want to represent yourself, you sign the judge's explanation and the waiver of counsel for purposes of the ineligibility. That's it. Does everyone understand? Okay. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. When a young man is sitting, we call that the jury box. 6 citizens will be selected to serve as jurors in your case. They will listen to all of the evidence. They will listen to the arguments. They will deliberate, and then they will decide whether to find you not guilty or guilty. You also have a right to waive your right to have a jury trial, means give up your right to have a jury trial. If you give up your right to have a jury trial, your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. Somebody might ask, how it's going to come before me by way of a trial if I waive my jury trial? Well, it'll come before the judge by way of what we call a bench trial. A bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to all of the arguments. The judge will apply the law to the facts of the case, and then the judge will decide to find you not guilty or guilty. Another way that your case can come before the judge is by way of an agreed plea bargain. That is, if you're in the state have reached an agreement, or you and your attorney in the state have reached an agreement, that means you're going to have a plea bargain, you're going to settle your case. It comes before the judge by way of an agreed plea bargain. Now, if it comes before the judge by way of an agreed plea bargain, the judge can do one of 2 things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you can take your plea back. And basically what that means is this. Let's say you're in the state that worked out a plea bargain agreement, and let's say the state said, well, judge, we're going to give this person 1 day in jail. Okay? And the judge says, well, I'm not going to follow that plea bargain agreement. I reject that plea bargain agreement. And if that's the case, you can tell the judge, well, judge, I take my plea back. In essence, I'm withdrawing my plea. You can take it back if the judge don't follow the plea bargain agreement. Now, if the judge does follow the plea bargain agreement, and if within 30 days of the plea bargain agreement or of your case being disposed of 30 days of the judgment, you say to yourself, you know what, I want to appeal this case. If you want to appeal the case, then you have to get permission from the judge that followed or accepted the plea bargain agreement. Okay? Now, the other way that your case can come before the judge is by way of an unagreed plea bargain agreement. Okay, let's say you're in the state that worked out a deal. The state said, well, our agreement is for you to do 180 days in jail. You say, well, I'm not gonna go, I don't wanna do 180 days in jail. I'm not gonna go along with that plea bargain agreement. So you don't have an agreement, but I want the judge, you say, I want the judge to set my punishment. In essence, the judge sets the punishment. That's when we call it unagreed plea bargain agreement, okay? Now, as a defendant in a criminal case, you also have a right to have witnesses that come to court. Witnesses sit in that chair right there that has the microphone in front of them. We call that the witness stand. Now, a witness, they can testify for you or against you. If you represent yourself, you can ask a question. If you have an attorney, your attorney can ask a question. We call that a direct examination or cross-examination when you're asking a question. Now, you also have a right to waive or give up the right to have witnesses to come to court. If you waive or give up the right to have witnesses to come to court, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses because they will be calling witnesses. Okay? Now, you also have what is called a Fifth Amendment right against self-incrimination. I know a lot of times we see a lot of these law shows on television, and you might see somebody, police go up to them, ask them some questions, and the guy or the woman might say, I take the fifth. What they're saying is, I have a right to remain silent, and I'm gonna maintain my silence. And there's nothing you can do about it. Because I have the Fifth Amendment right, United States Constitution, to remain silent. It's the Fifth Amendment right against self-incrimination. Now, I'm saying that to say this. If you're in trial and you exercise or invoke your Fifth Amendment right against self-incrimination, the state, the government, the DA's office cannot call you as a witness, force you to take the witness stand. Because you exercise your Fifth Amendment right against self-incrimination, they can't do that. Now, you can waive or give up your Fifth Amendment right against self-incrimination. That means that you're not exercising, you say you want to take the witness stand, you can do that as well. Okay, but as long as you exercise your Fifth Amendment right against self-incrimination, they cannot force you to take the witness stand. Now, the other right that you have a right to have what we call discovery. And basically, I guess, a good example of what that means is you have a right to discover or see what's in the state's file, the evidence that they'll be using against you. Okay? And you have a right to see your statements, witness statements, police reports, lab reports, any type of documents. You have a right to see video recordings, listen to audio recordings, see photos, instruments, if they have some type of instruments that they have. You have a right to see those things. Now, you also have a right to waive or give up your right to have discovery. And by doing so, you will not be having any discovery, you will not have access to the evidence in the case. Now, as a defendant in a criminal case, first of all, I know everyone is here today for a case. You've been arrested, you bonded out of jail. You're either out of jail on a cash bond, which means you pay the full amount of the bond to get out, cash. Or you're out of jail on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you are out of jail on a PR bond or a personal recognizance bond, which means you didn't have to pay no money to get out of jail. You were released under your own personal recognizance with a promise to appear here today, to appear in court today. Now, I say that to say this. Every day that you spent in jail, that jail time can be used as credit toward your punishment. Now, listen to this. I say every day that you spent in jail. I'm not talking about 24 hours. So for example, let's say you were arrested and you was booked in jail at 11:59 p.m. last night, right? You got out of jail 2 minutes later at 12:01 a.m. That's 2 days. You've been in jail 2 minutes, but you get credit for 2 days because it's 2 different days. All right? Now, every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. And let's say you're in the state that worked out a plea bargain agreement for you to serve 5 days in jail. What that basically means is you won't have to serve no more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they offer you 7 days in jail and you spend 5 days in jail, you get credit for the 5. That means you only have to spend 2 days in jail. We'll take 5 from 7, that leaves 2. Now, everything that you spent in jail also could be used as credit toward your fine and court costs. You are credited $100 per day toward your fine and court costs. So if you spend 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500 as a plea bargain agreement, that means you don't have to pay anything because the 5 days that you spent in jail, which is $500, is already paid off. Now, if they're saying that your fine and court cost is $700, that simply means you're gonna have to pay $200 because you already have $500 paid. We'll take the 5 from the 7 and leave 2. Now, you're required to pay the $200 on the day that you've entered your plea. Now, if you cannot pay it, we can put you on a payment plan. In essence, you can pay so much of money until it's paid off. Now, let's say even if we put you on a payment plan, you can't pay it off because you don't have an income. You might not be working, you just don't have an income. No problem. Because we can convert the fine and court costs to community service. For every 1 hour of community service that you perform in a nonprofit organization, you will receive $12.50 that will go toward your fine and court costs. So in essence, it's $12.50. If you do an 8-hour one day, that's $100. That will go towards your fine and court costs. So in this scenario, you got $200. You do 2 8-hour days of community services, you've already paid it off. All right. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, first time getting in trouble, Jefferson County, and when I say Jefferson County, I'm talking about the district attorney's office. They have a program that is called pre-trial diversion. And what that means is they will dismiss your case and you can get it wiped off your record. You can get what they call an expulsion. Erased, deleted, or wiped off your record. First time offender. Now, in order to qualify for the program, that's be your first time getting into trouble. 2, it can be an offense involving unlawful carrying a weapon or resisting arrest. And 3, you have to have an attorney to assist you with the application process. So if you qualify, get into the program, they dismiss the case, you complete the program, you can get an expulsion. Wiped off, deleted, erased your record like it never happened. Like if this is your record right here, when it's expunged, it's like this. It's nothing on it. All right, it's gone. All right, now, Jefferson County also has another program for veterans only. If you are a veteran of any one of the branches of the United States military, they have a program, the DA's office has a program that is called Veterans Court. It's for veterans only. Only thing to be eligible for the program, you have to be a veteran of any one of the branches of the United States military. That's the qualifications again. And so if you are, then you get into the Veterans Court program. What they will do, once you get into the program, once you complete the program, case get dismissed, you can get a non-disclosure. Spoke about a non-disclosure earlier when your record is sealed. Okay? To the general public. Now, if you're interested in any one of those programs, just let us know. And we have some brochures that we can give to you to direct you to the people that you need to talk to. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that I started within the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI stands for Community Safety Initiative, CSI. With that program, the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. Well, we address that through our CSI program. With the CSI program, we have partnerships with agencies in the community. One of the agencies that we have a partnership with in our community is the Spindletop Center. Spindletop is our local mental health authority in the Southeast Texas region. And what Spindletop will do, Spindletop will come in and they can give you what is called a private interview. It could be in our jury room, it could be at their facilities, it could be by phone, whichever is convenient for you. They also have the ability to do what is called an assessment to basically determine what your mental health illness is. Also, they have the ability to refer you or treat you for either outpatient or inpatient treatment, depending on your mental health needs. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any other host of mental illnesses, and Spindletop has the expertise to address those issues. If you have issues with drugs or alcohol, Spindletop has another program that is called ATAR, A-T-A-R, ATAR, and it stands for Addiction, Treatment, and Recovery. We also have a partnership with the Golden Triangle Empowerment Center that has a program that is called OSAR, O-S-A-R, that stands for Outreach, Screening, Assessment, and Referral. Now, both of those programs are similar. What they will do a screening, an assessment, and then you could be referred for either outpatient or inpatient treatment to address your alcohol or drug needs. If you are unemployed, do not have a job, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. If you have not graduated from high school or you do not have your GED, well, CICE has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I've just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take out time. That means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so if you're interested in any one of these programs, just let us know. And I tell people that when you come to County Court at Law Number 2, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know, and we'll be happy to assist you at getting in these programs. Now, we're going to take a break. And the reason why we're going to take a break is because the paperwork that you have on the clipboard, we need to pick that back up from you. And it's gonna take us some time. If you need help with filling out the paperwork, we have our core personnel who will be happy to help you with filling out that paperwork, okay? And just, now, if you need to use the restroom, there are two restrooms right outside next to the courtroom, in the hallway. The women's restroom is in front of county court. No, the women's restroom is on the opposite side of the hall, in front of the 172nd District Court. And the men's restroom is on this side of the hall, in front of county court at law number 3. Now, you'll be allowed to go out in the hallway, use the restroom. Do not leave the courthouse. If you leave the courthouse, and if your name is called, you're not here, your bond can be forfeited. That is, a warrant can be issued for your arrest. Okay, you'll be arrested and placed in the Jefferson County Jail, and then you'll see me again. Okay, doing the same process all over. All right. So again, if you need some help with the paperwork, just let us know. Just raise your hands. Good. All right, and we'll be able to help you with the paperwork. Now, again, just a brief cap. If you want to hire an attorney, you only sign this one page and you're through. If you want to apply for a court appointed attorney, sign this page and the affidavit of indigence. If you want to represent yourself, sign this page and the waiver. That's it. All right. And then we'll pick that up from you. Again, ladies and gentlemen, I'd like to thank you for your time and attention. We're going to try to get through this as fast as we can. And then once we get all the paperwork and evaluate it, we're going to call you up before the bench. You come up before the bench one at a time. And then we should be out of here no time flat. Okay? All right. So again, ladies and gentlemen, again, if you need to use the restroom, you can go in the hallway. If you need assistance, we'll come out and help you with that. And then I'm gonna call some people up to the bench to help as well. Now, let's do this here. I think this gentleman had his hand up first. Why don't you come on up to the bench, and I'm gonna work with you on yours. If you are, yeah. Hold on a minute. Uh-oh. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First two cases are cause numbers 24-CCCR 1586 and cause number 24-CCCR 1846. Both cases are styled State of Texas versus Sidney Darcy. Mr. Darcy, is that your full name? Yes. Mr. Darcy, would you please raise your right hand? Mr. Darcy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Mr. Darcy, you may put your hand down. Now, Mr. Darcy, I have before me, well, first of all, Mr. Darcy, how are you doing? Good. Doing good? That's good. I'm doing fine. Thanks for asking. And Mr. Darcy, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Yes, sir. Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? Yes, on the next document, this document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? Yes, Mr. Darcy, before you sign and initial these documents that I just showed you, did you read the documents? Yes, sir. Did you understand what you read? Yes, sir. And is everything in these documents true and correct? Yes, sir. To the best of your knowledge? Yes, sir. Mr. Darcy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. Attorney that's appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you can follow the bailiff, and you have a blessed day. Please stand in front of the court coordinator. He can, where you gonna have, where you want him to sit? Okay. What? But he has,
Yeah.
yeah. It's what he's being arrested on, so it was. Next case is cause number 24-CCCR 2034. Case is style of State of Texas versus James Fasulo. All right, Mr. Fasulo, your full name is James Anthony Fasulo?
Yes, sir.
How are you doing, Mr. Fasulo?
Good, how are you doing?
I'm doing fine. Mr. Fasulo, would you please raise your right hand? Mr. Fasulo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Fasulo?
Good.
You doing good? That's good. Now, Mr. Fasulo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendants?
Yes, sir, it is.
And are these your initials on the line that state you would like to hire your own attorney?
Yes, sir.
Now, Mr. Fasulo, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Fasulo, your case is going to be reset to give you an opportunity to hire an attorney. Our court coordinator is going to reset your case. Please have a seat in that first chair on the wall.
Yes, sir.
Justin Monk. Mr. Monk,
Sir.
your full name is Justin Monk.
Yes.
Mr. Monk, would you please raise your right hand? Mr. Monk, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Monk, you may put your hand down. How are you doing, Mr.
I'm
Monk?
doing all right.
You doing all right? That's good. Mr. Monk, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defender Signature. Is this your signature?
Yes, sir.
Mr. Monk, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true or correct to the best of your knowledge?
Yes.
Mr. Monk, I read your answers. To this, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him.
Yes, sir.
Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
All right, thank you, sir.
Okay, just have a seat in that second chair. You can push it on the wall. Thank you. Jasmine McDaniel. For the record, your name is Jasmine Nicole McDaniel. Ms. McDaniel, would you please raise your right hand? Ms. McDaniel, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. McDaniel, you may put your hand down. How are you doing, Ms. McDaniel? I'm doing fine. Thanks for asking, my Ms. McDaniel. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that is titled defendant's signature. Is this your signature?
Yes.
Ms. McDaniel, before you sign and initial these documents, did you read the documents?
Yes.
Understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. McDaniel, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that's appointed to represent you in this case is Attorney Peter Doyle. Attorney Doyle will be given information to contact you, and you will be given information to contact him. But before our court coordinator give you that information, I need to give you some bond conditions. The bailiff is going to hand you a document that is entitled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
I'm going to go over these bond conditions with you. And it states as follows. Standard bond conditions in County Court at Law Number 2, following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, defendant shall submit to testings for drugs and alcohol as directed at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when ordered to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim. The pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. You understand that condition? And condition number 4 does not apply. However, on the next page, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Ms. McDaniel, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will reach you for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes.
Okay, so now, Ms. McDaniel, as I mentioned earlier, our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. You have a blessed day and hope that you have a healthy baby.
Thank you.
You're welcome. Just sit down in that first chair. Dylan Broussard. Mr. Broussard, your full name is Dylan Gerard Broussard. Mr. Broussard, would you please raise your right hand? Mr. Broussard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Broussard, you may put your hand down. How are you doing, Mr. Broussard?
I'm doing fine with yourself.
I'm doing fine, thanks for asking. Now, Mr. Broussard, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials
Yes,
on the
sir.
line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Broussard, before you sign and initial these documents, do you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Broussard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information.
I have a question whenever you finish.
Okay, once she gives you that information, you'll be free to go. You have a blessed day. Now, you had a question.
Yes, sir. I have a drug patch right now, and I'm not able to maintain the payments. I want to see if there's any way that I can do randoms.
I didn't order that you had the drug patch. Whoever ordered that. I don't have no authority to order. I mean, I can order it, but I didn't order it. So another judge must have ordered it.
Okay.
So whoever that judge was, you need to ask, you have to go before that judge.
I've been trying to get in contact with that judge. I'm having.
Okay, but he's the only judge that can order you to do something other than his order.
Okay.
Okay?
Yes, sir.
Now, the other thing is I have some bond conditions that I need to give to you. The bailiff is going to give you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over this document with you.
Yes, sir.
And it states standard bond conditions in County Court at Law Number 2. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply, and condition number 4 does not apply. However, condition number 5 does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that
Yes, sir.
condition? Now, Mr. Broussard, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest.
Yes, sir.
Now, Mr. Broussard, do you understand that?
Yes, sir.
Okay, now, Mr. Broussard, as I mentioned to you earlier, you have been an appointed Attorney Mark Faggett. So you're going to be given information to contact Mr. Faggett by our court coordinator. Once you get that information, you're free to go. And you have a blessed day, and you can ask Mr. Faggard about the patch.
And I have one
See if he can do something for you.
and I have one more question. How do I get in touch with the spindle top and the thing with Lamar?
Okay, hold on a minute. Ah,
Somebody give me one of these?
You could give him one of those. That's spindle top? Yeah,
Yes, sir.
and this is the thing on Lamar. This is the job training program,
Yes.
and I think she gave you a brochure for spindle top,
Yes.
okay?
Yes, sir.
All right.
Thank you.
All right, Mr. Russo, just have a seat and wait for your name to be called. Oh. Darcy was first. He was the guy that got arrested.
I mean, I have, but it's good.
You still have to give him his paperwork, huh?
Yeah, I do.
Justina Sheree Joseph. Ms. Joseph, your full name is Lestina Sheree Joseph. Ms. Joseph, would you please raise your right hand? Ms. Joseph, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Joseph, you may put your hand down. How are you doing, Ms. Joseph? That's good. Ms. Joseph, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that is titled Defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for a court-appointed attorney? On the next document that is titled Jefferson County Affidavit of Indigence, do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Ms. Joseph, before you signed and initialed these documents, did you read the documents?
Yes.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, and I got help too. I had asked for help. The lady came in and helped me and overlooked it for me.
Okay, so you had someone to assist you as fill out the document. Okay, now, Ms. Joseph, before you signed and initialed these documents, did you understand everything?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Joseph, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact him. Our court coordinator is going to give you that information. Once you get that information, you'll be free to go, and you have a blessed day.
Thank you.
You just have a seat in that second chair on the wall. Andrew Dwayne Bell Morales. Mr. Morales, your full name is Andrew Dwayne Bell Morales.
Yes, sir.
Mr. Morales, would you please raise your right hand? Mr. Morales, do you swear or affirm tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Morales, you may put your hand down. How are you doing, Mr. Morales?
Doing good, how are you?
I'm doing fine, thanks for asking. Mr. Morales, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that states defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir. And I might put in the box, somebody help me, just moving to the clip.
Oh, yeah, okay, I saw that. And she had already told me. Also, I have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Morales, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Morales, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. And you will also be given information to contact him. Court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat on that third chair on the wall. You have any please ready? Who do you need? Kennedy Coleman. You can put it. That's your part. Put that on on the table right there. Right. Yeah. Okay. Ms. Coleman, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Coleman, you may put your hand down. How are you doing, Ms. Coleman? I'm doing fine, thanks for asking. Now, Ms. Coleman, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document? Now, and is this your signature on the line that's titled Defendant? Ms. Coleman, before you sign and initial these documents, did you read the documents? You understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay. Now, Ms. Coleman, I have before me a document that was filed by the Jefferson County District Attorney's Office. This is a order to dismiss. Is that correct, State?
That's correct, Your Honor.
Okay, so Ms. Coleman, I'm signing the dismissal on this case. Okay, Mr. Coleman, I'm signing the dismissal. You'll be able to get a copy of this dismissal in a few seconds. And you may be eligible for an expunction. You can talk to an attorney about that.
Okay.
To get this wiped off your record, okay. All right. Once you get a copy of the dismissal, you're free to go and you have a blessed day.
Thank you.
You're welcome. Michelle Christoph Herring.
Yes, sir.
Okay. Okay, this is cause number 23 CCCR 0122, case of style, the state of Texas versus Nishane Christoph Herring.
Yes, sir.
Mr. Herring, would
Yes,
you,
Your Honor.
is that your full name?
Yes, sir.
Mr. Herring, would you please raise your right hand? Mr. Herring, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Ms. Herring, you may put your hand down. How are you doing, Mr. Herring?
Good. And yourself.
I'm doing fine, thanks for asking, Mr. Herring. I have before me Well, before we get started, you have a right to have a record of these proceedings dictated. That means you have a right to have a court reporter to type down everything that's being said.
Right.
You also have a right to waive or give up your right to have a court reporter.
Okay.
Do you waive or give up your right to have a court reporter?
Waive it.
Okay. Now, Mr. Herring, I also have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, I do.
And is this your signature on the line that's titled Defendant?
Yes, Your Honor.
Are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled Defendant?
Yes, Your Honor.
Now, Mr. Herring, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct
Yes, Your Honor.
to the best of your knowledge?
Yes, Your Honor.
Okay? Now, Mr. Herring, I also have a document on my computer that's titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Nishane Christoph Herring, on or about November 2nd of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Herring, do you understand what you have been charged with?
Yes, Your Honor.
And to this charge, Mr. Herring, how did you plead? Guilty, not guilty, no contest? Now, you're pleading no contest freely and voluntarily?
Yes, Your
And
Honor.
are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Mr. Herring, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there are a set of initials. First set of initials is on a line next to a box that says check nolo contendere, which means no contest. Did you place your initials here?
Yes, Your Honor.
The second set of initials is the lower paragraph that's titled Discovery Admonishment, and is on a line next to a box that states, I do not request discovery, or I waive my right to discovery, and I do not request discovery in this case, and I enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, Your Honor.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document.
Yes, Your Honor.
And is this your signature on the line that's titled Defendant?
Yes, Your Honor.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, Your Honor.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, Your Honor.
Now, Mr. Herring, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, Your Honor.
And did you understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct
Yes, Your Honor.
to the best of your knowledge? Mr. Herring, are you a citizen of the United States?
Yes, I am.
Self for 6-1.
Mr. Herring, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on this tablet. This is the same document that have your initials in the 2 locations on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, Your Honor.
Mr. Herring, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Do you have any mental problems that affect your ability to understand what you're doing today?
Only thing I take is, psych meds.
Okay, but do you understand what you're doing?
Yes, sir.
Okay. Now, Mr. Herring, I'm going to find, well, first of all, I will accept your plea of no contest.
Yes, sir.
I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement is 120 days time served, court cost tax returned in this case.
Okay, Mr. Herring, state is offering that you serve 120 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 121 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means you will not have to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Herring, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Herring, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Herring, you're gonna stand in front of the court coordinator, follow the bailiff. Once you finish following the bailiff's directions, you will be free to go, and you have a blessed day.
Yes, sir. You have a blessing too.
Thank you. Please stand over here next to the bailiff. Shantae Martin. A card. Bring a flyer. It's just they don't have none in the it's just the only two. There you go. This might, yeah, that's the mobile board.
Yeah, maybe, I have to know somebody. I'm gonna look on the court back there.
I think I might. Here's this. She doesn't work in it. I'll just give her this one. Have a number. No. Yes, I can speak to this one. You have another one? That's the veterans program. What's the other one? That's what she looked at, or they might have some in that, this sheet. Okay. Okay, this is cause number 24 CCCR 2050, case of South State of Texas versus Shantae Naomi Martin. Ms. Martin, is that your full name?
Yes.
How are you doing, Ms. Martin?
I'm doing good.
That's good. Now, Ms. Martin, would you please raise your right hand? Ms. Martin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Martin, you may put your hand down. Ms. Martin, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that states you like to waive your right to attorney to represent yourself? I also have another document that is titled Waiver of Counsel for Purpose of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
I do.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Ms. Martin, before you finish signing, or before you sign and initial these documents, did you read the documents?
I did.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay? Now, Ms. Martin, pursuant to, now, in this here, you stated that you wanted to waive your right to an attorney and represent yourself, is that correct?
Yes.
And it's now pursuant to the case of Beretta versus California, I need to ask you some questions. Okay, first question, have you ever studied law?
No, sir.
Okay. Have you ever represented yourself in a criminal action?
Can you repeat that one for me?
Have you ever represented yourself in a criminal action?
No, sir.
Okay. Do you understand the charges against you?
I do.
You do? All right. And are you aware of the maximum penalty if you are found, if you are convicted and found guilty of, for this charge?
Yes, sir.
You're, okay. Are you familiar with the legal, or the exact legal elements for each charge? That is, are you, oh, well, do you understand what the state is required to prove in order to find you guilty?
No, sir.
Okay, so let me ask you this. Now, you realize that if you if you are found guilty, your punishment can be assessed at up to 180 days in a county jail, or you could be given a fine up to $2,000, or you could be given both such fine and confinement.
Oh, I understand that much, yes.
Okay. Now, do you realize that if you represent yourself, you're on your own?
Right.
That is, as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. You understand that?
Yes, sir.
I cannot help you in any way. You understand that?
Yes, sir.
Okay. Are you aware, or excuse me, are you familiar with the Texas Rules of Evidence and Texas case law?
No, sir.
All right. Do you realize that Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules.
Can you do it one more time?
Okay. Do you understand that the Texas rules of evidence and Texas case law govern what evidence is admitted and that's admitted into your trial? And in representing yourself, you must abide by those rules. Just like everything, there are certain rules. Example, if you play baseball, baseball have rules, basketball have rules, everything basically have rules. And so in a court of law, we have rules of evidence and we have case law. That is the law that has been interpreted by the judges. Okay. Now, what I'm saying is that those rules govern how the court, well, in the rules of evidence, it determines or governs what evidence comes in and what evidence stays out. And you have to know those rules if you're trying to get evidence in or keep evidence out. You understand that?
Yes.
All right. Do you know how to conduct a voir dire examination?
I'm not sure what that is.
Okay. That means to pick a jury. What are the grounds for excusing a juror for cause? Do you know that?
No, sir. Meaning being judged by my peers or?
What if you need to get a juror who is being considered for the person is on what we call the panel, and if they be considered to be a person on the jury, do you know how to challenge them for cause to keep them off the jury? Do you know the rules that governs that?
No, sir.
Okay. Do you know what hearsay is? Hearsay. Hearsay, that's a rule in the rules of evidence. Certain evidence could be considered hearsay. Do you know that?
I did not know that.
Okay. Do you know, well, if you don't know hearsay, you don't know what the exceptions to hearsay are either, right? The exceptions to the rule of hearsay. Okay. Do you know what is proper impeachment evidence? In essence, how to impeach a witness?
I do.
Okay. Do you know when and how to move for a directed verdict? Okay. Do you know how to offer evidence or proffer evidence to protect the record for appeal?
I do not.
Okay. Do you know the proper grounds for mistrial? How to declare a mistrial?
No, sir.
Okay. Are you aware that failure to timely move for mistrial may cause crucial mistakes made by the state, may waive crucial mistakes made by the state or this court? Do you understand that?
Yes, understood.
Okay. Do you know how to request and object to jury instructions?
Also, no.
Okay. Are you familiar with the Texas rules of criminal procedure?
I can say I do.
Hmm?
I can say I do.
Okay. Do you realize that those rules govern the way in which a criminal action is tried in court? Okay. Well, at this point, I must advise you that, in my opinion, you would be better defended by a trained attorney or lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with court procedure. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Do you understand?
Yes.
Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer? Okay, so you want to see if you can apply for a court-appointed attorney? Okay, so we need to give her an affidavit of indigence. And I need to give her, I'm gonna give you this, give her this form back because she need to make a change since she want to apply for court-appointed attorney. And you can probably take a seat at the, you can move that chair up to that table and you can sit there and fill out the paperwork. When you finish, we'll call you back up. We need to get Jennifer.
You go on there? She back.
Okay. Miss Oraji, I think they still have his paperwork out there. I don't, because I don't have it. The gentleman with the black shirt. He can have him to come on out. Thank you.
Yes, sir. Happy birthday, by the way.
Oh, thank you. Okay. This is, let's see. Okay. Donald, Enrique Rojas, definitely. Okay. This is cause number 24 CCCR 1934, case of style of state of Texas versus Donald Enrique Rojas Davila. And we have Mr. Rojas Davila present. He speaks Spanish. He may speak some English. However, we have Ms. Jennifer Raji, who is our interpreter. Ms. Raji, would you please raise your right hand? Do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
Ms. Raji, you may put your hand down. How are you doing, Ms. Raji?
Good, Judge. Thank you for asking. Yourself?
I'm doing fine. Thanks for asking as well. And Ms. Raji, ask Mr. Davila if his full name is Donald Enrique Rojas Davila.
Su nombre completo es Donald Enrique Rojas de Vila. Yes, sir. Yes.
Okay. Ask him to raise his right hand.
Levante la mano derecha.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Haces el mandato frente a Dios. Yes,
Okay,
Judge.
you may put your hand, put his hand down. Ask him how he's doing.
¿Cómo está? Bien.
Good?
Good, good.
That's good. Now, Mr. Rojas. Tell Mr. Rojas, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Ask him if he recognizes this document.
Es el documento que tengo enfrente. ¿Sí que puedes firmando ese documento? Sí. Yes, Judge.
Is this your signature? Ask him if this is his signature.
Y ese es su firma ahí completo. Yes, sir.
And ask him if these are his initials on the line state he'd like to apply for court appointed attorneys.
Y pusiste sus iniciales diciendo que querías aplicar para un abogado.
Yes.
Also have another document. It's titled Affidavit of Indigence. Ask him if he recognized this document.
Y si te puedes ese documento también.
Sí. Yes, Judge.
And asks him on page 2, if this is a signature above the line, it's titled defendant signature.
Y ese es su firma completo ahí.
Yes.
Okay, now, you can ask him, before you sign these documents, did you, Mr. Raji, go over these documents with him in Spanish?
Okay. Antes de firmar esos documentos, sí te explico todo en español.
Yes.
And ask him if he understood everything that you went over.
Y sí entendí todo lo que te expliqué.
Yes.
And is everything in these documents true and correct to the best of his knowledge?
Y todo en esos documentos son de verdad.
Yes.
Okay. You could tell him that I read his answers.
Sí te leí. Sí te
Based
leí
on his
tus
answers,
respuestas. No.
he meets the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent him is Attorney Charles Ross.
Dice que se cuida toda la información y sí la corte para afrontar una abogado. Se llama Charlie Rojas. Y él, sí, y él habla español.
And you could tell him that Attorney Rojas will be given information to contact him. And he will be given information to contact Mr. Rojas.
Y dice que le van a mandar la información de usted a él y la información de él le van a dar a usted.
Okay?
Y ahí enfrente de la señora le van a dar toda la información y la cita nueva para el doctor.
Okay, ¿me va a dar la información del abogado entonces?
Sí,
¿Su nombre?
sí,
Okay.
ahí enfrente.
Okay, and tell him to have a blessed day, and you have a blessed day as well, Mr. Raji.
Thank you.
Thank you, Judge.
You are.
Thank you.
Okay. No, don't make it turn, I will show him because this is really
See, okay. Okay, we don't. Okay, next case is Edward Sellers. Okay, we'll wait for, okay, this is, cause numbers 24-CCCR-0208, cause number 24-CCCR-0209, and cause number 24-CCCR-0354. All three cases are styled the state of Texas versus Edward Calvin Sellers. Edward Sellers is scheduled to be in court this morning at 9 a.m. at or about 9 a.m. The court's bailiff called the name of Edward Sellers at the courthouse door. Edward Sellers did not answer. Edward Sellers has not appeared in court since the court's been in session. The time now is 11:56 a.m. on today's date of November 5th of 2024. Ms. Bailiff, would you please call the name of Edward Sellers at the courthouse door?
Edward
Yes, ma'am.
Edward Sellers.
Oh, she got it? Okay.
No response, Your Honor.
Okay, Edward Sellers' name was just called again at the courthouse door. Edward Sellers did not answer. A reasonable time has passed to give Mr. Sellers an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Edward Sellers' bond will be forfeited. The warrant should be issued for his arrest. And just for the record, Mr. Sellers' attorney, Ms. Jennifer Delage is present in court. Okay. Mr. Lodge, you're free to go,
Thank you, Your Honor.
and you have a blessed day.
Thank you. By the way, I'm feeling much better. Appreciate you giving me a little slack the other day.
Oh, okay. Appreciate it. Yeah, no problem. Glad to see that you're feeling better. Yeah, I need to. Next case is Christine Butler. Cause number 24 CCCR 1894. Case is style state of Texas versus Christine Michelle Butler. Christine Butler was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Christine Butler's name was called. Christine Butler did not answer. A reasonable time has passed to give Ms. Butler opportunity to appear in court. The time now is 11:58 a.m. on today's date. Ms. Bailiff, would you please call the name of Christine Butler at the courthouse door?
No, she was on Zoom.
Oh, she was?
That's what the medical emergency
Huh?
said.
Oh, they said she was on Zoom.
Oh, she was, yes.
Okay, so we need to, we're gonna reset her case. She had a medical emergency. Okay, next case is cause number M 333-464. Case is style of state of Texas versus Oscar Rolando Gonzalez. Oscar Gonzalez was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's barely called the name of Oscar Gonzalez at the courthouse door. Oscar Gonzalez did not answer. The time now is 11:58 a.m. on today's date on November 5th, 2024. Ms. Bailiff, would you please call the name of Oscar Gonzalez at the courthouse door?
Oscar Gonzalez. Oscar Gonzalez. No.
Oscar Gonzalez's name was just called again at the courthouse door. He did not answer. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Next case is cause number M 333-872. Case is style of state of Texas versus O'Shea Harrison. O'Shea Harrison was scheduled to be in court this morning at about 9 a.m. At about 9 a.m., the court's barely called the name of O'Shea Harrison at the courthouse door. O'Shea Harrison did not answer. The time now is 11:59 a.m. on today's date. Ms. Bailiff, could you please call the name of O'Shea Harrison at the courthouse door?
O'Shea Harrison. O'Shea Harrison.
You have to reset it first.
North Sunshine.
O'Shea Harrison's name was just called again at the courthouse door. O'Shea Harrison did not answer. Reasonable time has passed to give O'Shea Harrison a time to appear in court is not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
O'Shea Harrison bond will be forfeited. Warrant should be issued arresting clause number M 333-872. Last case is clause number 24 CCCR 2138. Case in style of state of Texas versus Gregory Patrick Woods. Gregory Woods was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Gregory Woods at the courthouse door. Gregory Woods did not answer. The time now is 12 o'clock noon. Ms. Bailiff, would you please call the name of Gregory Woods at the courthouse door?
Gregory Wood. Gregory Wood. North Sunshine.
Okay, Gregory Woods' name was just called again at the courthouse door. Gregory Woods did not answer. Reasonable time has passed. Give Ms. Woods an opportunity to appear in court. State, do you have a motion?
State moves for bond forfeiture.
That motion was granted. Gregory Woods' bond will be forfeited and a warrant should be issued for his arrest. In clause number 24 CCCR 2138. And this will conclude the calling of the court's arraignment docket. And the court will reset Ms. Shantae Martin case for an announcement. And Ms. Martin, you'll, since you're representing yourself, you have to get with the district attorney's office for discovery. That is so that you can have access to the evidence that they have in your case. Okay, so your case is gonna be reset for an announcement. Okay, once you get your reset, you're free to go, and you have a blessed day. Now, these are one of these prosecutors, I don't know who case it is, but you're gonna have to make an appointment with the DA's office to visit the district attorney's office if you wanna have access to your case. Okay. Okay, once you call your name and give your reset, you're free to go, and you have a blessed day. Okay, this will conclude the calling of the court's docket on the day's date, November 5th, 2024, in County Court at Law Number 2. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.
Thank you, Judge.
Thank you.
Thank you, Judge.
Thank you.
Happy birthday.